Good afternoon. I am Andrea Walsh, and I represent the defendant of this case, Ashford Hospital. The case in question is that of Joseph Garga, alleging that his personal health information has been compromised due to misgivings within our institution. There are a few things that we need to cover in order to better understand why this is not what happened. First, we will start with the fact that HIPAA and the privacy rules set in place by HIPAA does not allow the right for a patient to sue an institution. It merely gives them an avenue to submit claims or complaints. The proper procedure should have been for Mr. Garga or his family to contact the Office of Civil Rights of DHHS, which is the Department of Health and Human Services, and allow them to take all the steps necessary to rectify the situation if the claims were founded. Nonetheless, here we are presenting a case in the court, so we will proceed. It has been said many times that a patient does not own their own medical records. The hospital, doctor's office, and institution owns the paper that it is written on or the computer that it is viewed on. With this mindset, we can agree that if an institution is entrusted with a patient's personal health information, they are free to use this information as it pertains to institutional operations. If a patient's personal health information is needed within the institution for billing or administrative uses, it needs to be provided. Now, let's look at all the facts. Mr. Garga's direct supervisor is a senior administrative lead and receives all types of documents in her company email that can only be accessed on the hospital's internal network. She gets these for administrative purposes on a daily basis. The document in question is the OR schedule. This is a document that is sent to her daily for her review. So just like every other day, she received the OR schedule in her email, which she reviewed because it is part of her job. Today, it happened to reflect that one of the direct employees was on her schedule. She did not approach her employee about his upcoming surgery. She didn't go into the break room and tell everyone else in their department. She just merely did her job. She simply used the document for recording purposes as she had every other day at work. We could take more time and look into the fact that the document was not de-identified, but considering that the correct legal action wasn't taken by Mr. Garga, that would prove to be inadmissible in this case. What we will take a look at is the fact that even if the document that went to Mr. Garga's supervisor did include his personal health information, it was not done to cause intentional harm. The person sending the email did his job as he had been trained. His job was to send the OR schedule to all the pertinent office workers to ensure that billing and administrative documents could be started. And Mr. Garga's supervisor did just that. She used the information to get all of the forms that will be needed for the upcoming surgery prepared, and then sent the information on to the billing department so they could start to work on the claim. This was all done according to Ashford Hospital's standard operating procedure. Everyone involved did their job as they were trained to do. According to 45 CFR 164.512 of the HIPAA law, it states, written authorization is not needed from patients if the intent is to distribute their personal health information within the institution for organizational purposes. No harm was done to Mr. Garga or his personal health information. There were no HIPAA violations. Nothing malicious was done. It was, simply put, all in a day's work.